My lords, the judgments are Speaker Haryana Vidhan Sabha versus Kuldeep Bishnoi, 2015, 12 SCC, 381, para 46 and 47. Then, and I'll later give the compilation numbers it's part of the compilation. Then, Pratap Gowda Patil versus the state of Karnataka, 2019, volume 7, SCC 463, para 4 and 7.
2019, volume
7, SCC, page 463, para 4 and para 7. Then Shivraj Singh Chauhan versus MP Legislative Assembly, 2020, volume 17, SCC, page 1, para 79 and para 80. Then Nabam Rebia versus Arunachal Pradesh Legislative Assembly, 2016, volume 8, SCC, page 1, para 188, 189, and para 191 to para 194.
Yes.
That's quite apart that it is absolutely obvious from these judgments that retains the right to participate. Also see the danger, my lords. If such MLAs against whom the disqualification is pending and they are suspending during pendency of their disqualification petitions, it would open up serious possibilities of misuse of 10th schedule. And I'll give some instances. The participation, of course, gets affected. So you, in a way, fix the eligible voters who will vote in the House. And major decisions to which some of the MLAs could have been inconvenient do not participate now in. And also, my lords,
that's very clear, actually, as a matter of first principle, because the mere pendency of the disqualification petition doesn't affect the status of the
and my lords, the moment your lordships have said they have every right to participate, quite apart from Article 180, that's the end of it.
That continues to be a
even 181 also, Article 181. When the speaker against whom the discussion only in the particular meeting,
yes,
correct, he cannot. Otherwise, he can speak. Even that meeting also he can speak.
Yes, absolutely right. But my lords, this point, your lordships are absolutely right, is very clear, but it acquires some significance because the argument being raised is that if his disqualification, he is held to be disqualified, Rana says it will relate back to that day, and thus any action taken with his vote, with the crutches aid of his vote, stands vitiated and suffers from a constitutional sin. That's why I said it's important. Because your argument is that it relates back, and because it relates back, every vote given by him, including the trust vote, goes, and thus your lordships, an exercise of your lordships' extraordinary jurisdiction, must overturn everything that has happened and act as a court of first instance.
Absolutely.
Then, my lords,
would have a very serious consequences according to you. Suppose the budget is passed and he has participated and cast his votes.
absolutely.
Correct? If it is to be restored back, correct, to his original one, then all this budgetary provision, all this.
Well, I can't put it better. Absolutely. And that is what is being sought to be argued. And this is, Rana never said this. Rana is, when I come in, I'll distinguish the judgments. Rana is in a different context. Mayawati is in a different context. Can you pick them up and apply them to a situation where they have no application at all? A line here, a line there, and you say that's the settled law on the point. Now, my lords, ground E, with your lordship's permission.
The member of legislators emolument act. There is a provision. Check up. What is the consequence of an MLA or an MP being disqualified upon his emoluments. There is a separate paragraph on that. Also,
My lord
gives
said
us
this
an
is the
indication.
MLA.
Sorry?
Your lordship said the MLA emolument.
Emolument. Just check that up. There is a provision.
I will. I'll look it up. I'll look it up today. Now, my lords has ground E. Sorry, question E. Question E.
Relating back.
My lord, the Chief Justice.
Yes.
If the decision of a speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? That's why, my lords, I put this, because that's been what they've been arguing right through.
Mr. Cole, D and E can be collected.
Yes,
go
yes,
together.
yes. But the reason I'm laying so much emphasis on is because a large part of this argument, where your lordship's order of 27th and 29 becomes according to them the cause of all that has happened, only your lordships can rectify, and the solution lies in this because it relates back to that day, and because it relates back to that day, and trust vote also falls in between, everything should be annulled.
Will you explain on the basis of Rana and other judgment that they have cited?
Well, what I'll do is,
No, whenever.
I'll in one go explain each of those judgments, because I'll explain Brahmanand Reddy, Rana,
So you
Nayak,
the
each one of them
judgments-
I'll distinguish
You will take up the judgments in one lot at the
in
end.
one lot.
All right.
Because, my lord,
Fair-
I have to cite my own judgments and I have to distinguish the judgments cited
all
by
right,
them.
fair enough. That would be
Relating
more
to
coherent.
relating back.
Sorry.
All this relating to relating back.
Yes. So, my lords, all those issues of Mayawati on political party versus legislature party in the 10th schedule, Rana status quo ex post facto, and the others, Manoj, as I go along, I'll deal with them. So, my lords, again, as far as this question is concerned, my argument remains the same as I just addressed your lordships on the previous. Yes. The law, the provisions of the Constitution, it cannot be any other way. This is the only way it can be. Because the consequences for an electoral democracy are disastrous. Constituencies go unrepresented. No one is there just because the disqualification petition is pending. And he will not participate in, especially when your lordships, this is no longer res integra. Your lordships have ruled on it, on judgment after judgment. Now, my lords, would your lordships be kind enough to have?
That's why in the context of the judicial function we have developed the concept of the de facto doctrine. So even if the appointment of a judge is found to have suffered from an invalidity, that will not render all the judicial acts as invalid.
Absolutely. I bow down to it. I bow down to it.
Be clearer.
There's now the next question is question F. What is the impact of removal of paragraph 3 of the 10th schedule?
Mr. Kaul, I have one small doubt. How are we going to deal with the situations which is emerging from time to time? Disqualification application is filed, speaker doesn't decide. And then the matter goes on. He participates in the assembly and a disqualified member continues. At what time and what is the time limit within which he needs to decide? Because till a decision is taken, disqualification issue is not decided, so therefore it's pending. This problem has been arising in a number of cases. Megha Chandra is one judgment where Nariman had to say that within a time limit he has to decide, but that's referred to a larger bench saying that you can't direct the speaker to decide.
And that,
But where are we going to
well, your lordships are
deal with a
absolutely right.
situation like this, where speakers don't decide and events overtake that, and either matters become infructuous or the house is dissolved by flux of time.
The lordships are right. It will have to be considered. Should there be a timeline? Should there be a time-bound process? should it be decided within a time-bound process or not? As your Lordship said, that issue whether such a direction could be given to
Can you
the
just pick
Speaker.
up that order where it's referred to the larger bench? That
Just
Meghachandra
Nariman's
reference to
judgment.
larger bench, can you just pick that up?
Yes. Yes.
I'll get hold of it, my lords. Let me just also apply my mind to this. It's fallen from my lords. But quite apart from the fact, my lords, when we were arguing Nabam, where we said that as far as the Speaker's own removal is concerned, the Assembly and the Constitution itself provided a reasonably strict timeline on how it could be followed in terms of when the notice to be given, when is it to be decided. Possibly some kind of a timeline. As the Lordship said, I'll have a look at the issue. Now, my lords, as far as the removal of the 10th schedule is concerned, my lords, firstly, this was only a defense against incurring a wrath under the 10th schedule. 3 and 4, para 3 and 4 are only defenses under the 10th schedule. That defense of 1/3 having split from the party is no longer available. But to me, it is wholly inconsequential because my case has never been that I have split or gone anywhere else. My whole argument has been that I represent the majority rival faction within the party. Neither have I given a support to any other political party, nor have I said I will not support a government as far as my own political party is concerned. As long as the coalition is something we've expressed our concern with, I've not gone anywhere. So this whole line of merger, split, it is not a case of a split, my lord. It's a case of a rival faction, or what the para 15 of the symbols order says, of a splinter group within the party.
What's the difference between a split and a
My lord, split is
and split on the one hand and what you are suggesting?
well, the difference between the two is that split is an issue where you, as a defense, say that I will not incur the wrath of 10th schedule. I have not even voluntarily left the party. In the case of a rival faction, I claim that I am the political party and recognize me as the political party under the symbols order. Please have that symbols order for a minute. It's a question that your lordships have put to me, a pertinent question, and this will answer. Please have statute compilation, PDF page 155.
Fact that there is a
seek your lordship's indulgence only for a minute, Lord. I'm taking this liberty only because I have to move an urgent application before my Lord District Jar chambers. No, no, just liberty to go to my Lord's chamber. That is all that I seek for that.
Image of the collective responsibility of the government to the legislature. The requirement of the trust vote fulfills that purpose in the present case. The present controversy has shone a light on the often fluid allegiances of democratically elected representatives. This is a matter for their conscience, and the court expresses no opinion on the matter. However, it is important to note that in directing a trust vote, the governor does not favor a particular political party. It is inevitable that the specific timing of a trust vote may tilt the balance towards the party possessing a majority at the time the trust vote is directed. All the political parties are equally at risk of losing the support of their elected legislatures, just as the legislators are at the risk of losing the vote of the electorate. This is how the system of parliamentary governance operates, and the learned senior counsel on both sides of the dispute congenially admitted that the outcome of the trust vote is the ultimate litmus test for the legitimacy to govern. However, we note that where the evidence indicates that circumstances of violence and coercion exist that would undermine a free and fair vote in the assembly, the governor and the court must take measures to ensure that the sanctity of the trust vote is maintained. In the circumstances as they have emerged in this case, the exercise of the authority by the governor was based on circumstances which were legitimate to the purpose of ensuring that the norm of collective responsibility is duly preserved. There existed no extraordinary circumstances for the governor to determine the trust vote was not the appropriate course of action on 16/3/2020. A significant ground of attack by Dr. Singhvi, learned senior counsel appearing on behalf of the speaker, on the decision by the governor to call for the trust vote is that convening a trust vote at this stage will impinge on the discretion of the Speaker to determine whether the resignation should be accepted under proviso to Section 190, Subclause 3, Subclause B, and at the second level, to decide upon the consequences of the resignation in terms of anti-defection provisions of the 10th schedule. Short-circuiting is the phrase which was used by Dr. Singhvi. Implicit in the submission is the charge that holding a trust vote impinges upon the discretion of the Speaker on whether to accept the resignations and to decide whether these members have incurred the wrath of disqualification. While analyzing the submissions articulated by Dr. Singhvi, the cobwebs need to be cleared. Governor does not decide whether the resignations that were submitted by the members were genuine and voluntary. That is squarely a matter which lies within the domain of the Speaker. Similarly, whether a member of the House has incurred disqualification under the 10th schedule is a matter where the Speaker is the designated authority. Conscious as the court has been of the fact that these are matters which lie within the domain of the Speaker, in the recent past, a direction to the members to appear before the Speaker and for the Speaker to take a decision immediately was recalled by a 3-judge bench. Dr. Singhvi alluded to these orders. It is straight law that neither the governor nor for that matter this court has the power to impinge upon the authority of the Speaker to take a decision on the above issues. The issue, however, is whether the convening of a trust vote has to be deferred until such time as the Speaker has taken a decision on whether or not to accept the resignations, and if so, the consequence of the members departing from the fold of the party on whose ticket they were elected under the 10th schedule. Holding of a trust vote operates in a distinct field from the issue as to whether one or more individual member of the Legislative Assembly have embarked upon a voluntary act of resignation or have incurred the wrath of 10th schedule. Holding a trust vote is necessary to ascertain whether the Council of Ministers, headed by the Chief Minister, has the confidence of the House. The continuous existence of the confidence is crucial to the legitimacy and hence survival of the government. It is a matter which can brook no delay, since the authority of the government presided over by the Chief Minister depends on the Council of Ministers continuing to have faith of the legislative body as a collective entity. particularly where the members resigned in an expression of the lack of faith in the existing government. The convening of a floor test is the surest method of assessing the impact of resignation on the collective will of the House. The consequence of acceptance of resignation is to reduce the numerical strength of the House. Until the resignations are accepted, the members who have resigned continue to be reflected in the strength of the House, having regard to the language which has been employed in Article 190, subclause 3, subclause B, shall thereupon fall vacant. Whether in a situation such as the present, an elected government is entitled to continue despite the resignations of 22 of its members has a significant bearing on the issue of confidence. Neither the governor, nor for that matter, the court can entrench upon the power of the speaker, but the pendency of the proceedings before the speaker cannot be a valid basis to not have the confidence of the House in the government determined by the convening of a floor test. Added to this is the factual circumstance in the present case that the Speaker Speaker accepted the resignations tendered by 6 of the 22 members on 14/3/20. All of the members sailed together. No explanation was forthcoming in the submission of Dr. Singhvi on what, if any, was the distinction between 6 members whose resignation were accepted with alacrity and the remaining 16 on whose resignations no decision has been taken. None of the members who resigned, neither the 6 or the 16, appeared before the Speaker. Therefore, non-appearance before the Speaker is evidently not a ground of distinction. We have highlighted the above factual scenario only to emphasize that the convening of a trust vote is of crucial importance to affirm the fundamental values of the Constitution, namely abiding by the rules which govern a parliamentary democracy. The fundamental precept of parliamentary democracy is that the government owes collective responsibility to the Legislative Assembly, and as a collective body, the Legislative Assembly is entitled to hold the government to account. The ultimate expression of accountability is the existence of or lack of confidence in the Council of Ministers. We are therefore unable to accept the submission of Dr. Singhvi that the holding of a trust vote would short-circuit the jurisdiction of the Speaker on a matter of resignation and disqualification. So, my lords, I just halt here for a minute. Your lordships dealt...
Before that, read para 82 also.
82, yes. During the course of his submission, Dr. Singhvi fairly accepted that the holding of a trust vote at this stage would ultimately only affect the ability of the resigning members to accept ministerial office in a new government, and that may be formed if the issue of disqualification has not been addressed in the meantime. Dr. Singhvi submitted that the effort in such cases is for resigning members to bring down a government on the allure of ministerial positions in a succeeding government, as the disqualification may not be accepted in future if the government were to change. This, as Dr. Singhvi submitted before the court, is how democratic politics operates in reality. The point of the matter, however, is that nothing prevents the Speaker from taking a decision either on matters of resignation or disqualification despite convening of a trust vote. That Speaker has not yet done so is not a ground to defer the convening of a trust vote. And my respectful submission is that these two submissions are not being made for the first time before your lordships, that immediately when the government is formed, a trust vote should only be held then and not later, and that if there is a disqualification pending, there should be no trust vote. These two submissions and arguments were categorically taken in Shivraj Singh Chauhan and categorically rejected in there. Because, my lords, ultimately, please see, who are we dealing with in this matter? We are dealing with three distinct constitutional authorities. We are dealing with the Speaker, who exercises and is the sole authority to exercise jurisdiction under the 10th schedule. We are dealing with the Governor, who's the sole authority to decide whether there should be a floor test or not. And we are dealing with the Election Commission, which under the symbols order, read with Article 324, is the sole authority to decide whether within a political party, a rival faction or a splinter group, as they say, has emerged or not. Now, repeatedly saying that there has been a split and you have not merged is of no consequence, because that is no one's case. I have never argued that I have split from the political party. We have never argued that we needed to merge with another parties. Those were defenses under the 10th schedule. Our consistent and continuous argument has been that we, within the Shivsena, represent the rival faction which ought to be recognized as the political party and has now been recognized as the political party in question in this matter. Now, my lords, if your lordships will recollect, and my lord, the Chief Justice also put a very pertinent question to me yesterday, that could it be argued by someone to say that because you expressed your dissatisfaction with the government in question or the chief minister in question, you would incur the wrath of the 10th schedule ex facie automatically. My lords, your lordships in Yadurappa and those line of judgments have categorically held that merely because a dissent is expressed within the party that we have no faith in the government in power does not mean that you're acting against the political party and you do not incur the wrath of Article 2(1) subclause A. Because till 2nd of July, my lords, 2(1)B does not get triggered. Both the disqualification petitions till 2nd of July 2022 are based on para 2 subclause 1 subclause A, whether you have voluntarily given up the membership of the party or not. And there we have respectfully submitted that time and again your lordships have interpreted it to say that there must be overt specific acts, moving with MPs to say that we are joining someone else, merging with another party. Those are overt acts which are considered. My learned friend cited one judgment where they said in the context to say that withdrawing support would also amount to the same. But please see the series of judgments, what they say. Yadurappa categorically says that merely because you go and say, I have no faith in the chief minister. In fact, there it was the chief minister. In our case, we don't even say that. Our case was not that we did not have the faith in the then chief minister to continue with the government. Our argument was that you cannot continue in the government in an MVA coalition with the NCP and the INC. Because, my lords, our resolution of 21st of June 2022 categorically said that your pre-poll alliance was with the BJP. Your post-poll alliance in this era of competing ideologies is with a person and a party with whom we've had serious differences for decades. And there is a vast discord and discontent amongst the cadres of the political party and the workers of the Shivsena. And thus we said that this is a case where there is internal dissent within the party. So right till 2nd of July 2022, it was only a case of 2(1)A, which Yadurappa squarely covers and says that merely because you express internal dissent, which is the essence of democracy, it cannot be treated to mean that you have voluntarily given up the membership of the party under 2(1)A. As far as the whip issue is concerned, my lords, which is a 2(1)B issue, on 21st, there was a whip appointed by us. They reiterate their faith in another whip. Both give their own categorical direction, which only comes into action on,
You appointed your whip
on the 21st of
There was
June.
already an existing whip, right?
No, Maharaj, there was an existing whip, but when overwhelming legislation, and I'll come to that, Maharaj, I'll just develop that argument.
So that we are flagging for you to answer that whip arising out of a legislative party, not the political party, that you answer.
Absolutely, my lords, I have, because that's one of the issues also framed by your lordships, and when I deal with the issues, I deal with that as well. But it's important, my lords, let me just revisit some of the timelines, my lords, because a lot has been said on these timelines, and it's important for your lordships to keep in mind these timelines. Just go that one. My lords, it is our contention kept it in the place lock folder.
Yes.
Abhi nahi. May I? Well, it is our contention, and now I'll just go through some of the important dates, just 7 or 8 of them, my lords, to say that the very act of filing a disqualification petition was in fact an attempt to stifle dissent in the party. after a resolution is passed and we express no confidence in the deputy speaker, suddenly a disqualification petition is filed. So our respectful submission is that 10th schedule cannot be used to stifle dissent within the party. And definitely internal dissent does not amount to voluntarily giving up the membership of the party under Article 21A. So, my lords, leading up to the 2019 elections, my lords, there was a pre-poll alliance between the Shivsena and the BJP.
So those timelines you're reading from somewhere, or?
My lords, these are just 5-6 dates I jotted down. I'm so sorry. I just jotted the relevant dates.
No
which
problem.
would
You
be-
can,
yes.
why don't you give us those dates so that we'll first take down those dates and then you can make your submission on that.
Yes.
If you can just give us those dates straight away and then you
Yes.
can make your submission.
I see, my lords. And what I'll
we can
also
then,
do, by the end of the day, I'll have a page typed out. Which I should have
Sure,
done.
no
I didn't
problem.
get the.
But you can straight away just 5 dates so we can take
Yes,
it down.
yes,
later.
5 or 6 days, my lords.
Just
So,
tell us those dates.
21/6/2022,
Yes.
22/6/2022.
What happened on 21/6?
Well, I just, should I?
Oh, you are giving
No,
the dates?
whichever way your lordships
No,
want.
that's
Should
okay. It's what-
I'll go.
Easier to type it out if
Yes.
you say 20.
No, my lords, I must confess, I thought your lordship said first give the dates, then explain what happened.
No.
So
I meant-
I'll just give with the event that
I
happened.
said, obviously,
Yes,
yeah,
I'm very.
that's what,
grateful.
yeah.
Very grateful. So, my lords, on 21st of,
It's easier to type it out.
Yeah.
on 21st June 2022,
Yes.
the first meeting of the majority of the Shinde faction of 34 MLAs takes place. "34 MLAs were present in this. Mr. Gogavale was appointed as the chief whip, and Mr. Prabhu's appointment as the whip was cancelled with immediate effect.
His chief whip was appointed by the legislative party.
My lords, that
Just-
yes, park it. I'll show to your lordships that this is not only the convention, this has the authority of the political party. So this whole argument that this is only the legislature party and not the political party, I'll demonstrate that. That is how it's been right through. This whole artificial distinction which has been drawn that it is the legislature party who did it and the political party had nothing to do with it, I'll come to it. That's a specific issue.
Let's go through the dates.
Yeah,
Give us
yeah,
the dates so that
yeah,
then we
yes,
can forfocus on
yeah,
that.
Yes, my lords. So
Dates and event, I mean, whatever.
date and events, my lords. So on 21st, my lords, Mr. Gogavale is appointed as the chief whip. Mr. Prabhu's appointment as the whip is cancelled with immediate effect. And a resolution is passed which categorically provided that there is enormous discontent amongst the cadres of the party for forming a government with NCP and INC, who are ideologically opposed to the Shivsena. The resolution also said that the act of entering into a coalition had a tremendous negative impact on the voters and the party cadres at large, and that there was hue and cry towards the party leaderships for the act of aligning with the opposing parties. And then it categorically says that the MLAs as well as the leaders and workers throughout the country are facing a lot of humiliating questions on this count. So this is what we did. On the same day, the minority faction within the party, which at that stage was 24, now is of course less than 14 or 14, whatever. 24 of them on that day,
On 21st June itself.
21st June itself, met and passed the following resolutions. One, removing Mr. Shinde as the leader of the party, because Mr. Shinde also had been a leader since 2019 of the legislature party. So they removed Mr. Shinde as the leader of the party. And they appointed Mr. Ajay Chaudhary as the leader of the legislature party. The resolution also recognizes Mr. Prabhu as having been appointed as a whip previously. On 21st itself, my lords, a notice was also sent by the majority faction, that is the Shinde faction, for removal of the deputy speaker. This notice was issued on behalf of and signed by 34 MLAs of the Shivsena Legislative Party.
Deputy Speaker. Remove him.
So is it not therefore clear that on the 21st, there are two clear factions. One, you claim that, well, there were 34 with you. And the others say that, well, there are 24. The 24 says, look, we are reiterating Sunil
21,
Prabhu.
21.
21.
Total is 55, so it's 21.
Right, 21. Not 24, 21.
21. Now, on 21st itself, the deputy speaker communicates to the minority faction that they have accepted Mr. Ajay Chaudhary as the leader and does not respond to our.
Come again?
On 21st itself,
Yes.
the deputy speaker or the undersecretary of the Maharashtra Secretariat communicates to the party that they have appointed Mr. Ajay Chaudhary as requested by the minority faction and does not respond to our communication at all. On 22nd of June 2022, a notice is given by the minority faction to attend an emergency meeting on the same day at 5 p.m. And the notice said if you fail to attend, it will be deemed to indicate your clear intention to voluntarily give up the membership of the party. That's been their only case of voluntarily giving up the membership
To
of the
attend a
party.
meeting on
22nd of June 2022.
same day. Meeting is to be held on?
My lord,
Same day meeting.
yes, on the same day at 5 p.m. At 5 p.m. On the very same day, my lords, on the very same day, the majority faction writes to say that Mr. Prabhu's letter stating, calling for a meeting, he had no authority to call for a meeting, and therefore the notice is invalid, as he had been removed from his position as the chief whip.
No, rights to?
The majority faction replies to Mr. Prabhu's notice because he had called a meeting the same evening of the minority faction. He was part of the minority faction, issued a letter calling for an emergency meeting at 5 p.m. on the same day.
They stated that he had no right to.
Because he had been removed on 21st as the whip by the majority faction. On 23rd June, the first disqualification petition on 23rd June, the first disqualification petition is filed before the Speaker, before the Deputy Speaker against 16 MLAs by Mr. Prabhu on the grounds that they had voluntarily given up the membership of the party to attend the meeting as they did not attend the meeting on 22nd.
First disqualification petition is filed before the Deputy Speaker.
On the grounds,
By Mr. Prabhu, no?
that's right.
That they had voluntarily given up membership.
Was your notice to the speaker for removal of speaker given?
On 21st of June 2022,
So therefore, that's one first date which you have.
prior in time.
That date hasn't come. So 21st is the notice given by your group for removal of the speaker.
Of the Deputy Speaker. Because there was no Speaker for the removal of the Deputy Speaker.
21st itself.
Yes.
So that 21st is cancellation of Prabhu's appointment as a whip and for also the removal of the Deputy Speaker.
It, my lords, has first Mr. Gogavle appointed as the whip.
Right,
Mr. Prabhu cancelled with immediate effect.
right.
The resolution that there is widespread discontent passed on the same day.
That we took.
And also the separate notice issued to the Deputy Speaker.
Yeah, that you're right. Huh?
It's not part of.
Separate notice for removal the Deputy Speaker.
Notice for removal.
Under Article 179C. Fellows, may I? Now on 25th of June 2022, disqualification notices are issued to 16 MLAs by the Deputy Speaker, asking the MLAs to file their replies by 5:30 p.m. on 27th June
Just
2020.
before that, 23rd June, the first disqualification petition is for how many people?
For 16.
16 MLAs.
Okay.
What is their argument?
Then the next one was 25th, no, you said?
Yes.
25th.
25th, disqualification notices issued to the 16 MLAs by the Deputy Speaker, asking them to file their replies by 5:30 p.m. on 27/6/2022. And 26th and 27th were the weekend. So these two non-working days are given to file a reply.
26th, 27th, which one is to call?
25th is when they are given a notice to file their reply by 27th.
By 20.
So intervening are two non-working days, which are 26th and 27th are both non-working days. It's the weekend. Now, on 25th, it's an important event, my lords. Even the Thackeray faction writes to the Election Commission. The minority faction writes to the Election Commission. So they go to the Election Commission to say that there is a rival faction which may set up a political party. And we are the Shivsena. They write to the Election Commission, invoke the jurisdiction of the Election Commission. And that order is not the subject matter before your lordship. The EC order which your lordships are dealing in another matter, where I've been recognized as the political party, categorically says that these rival factions had emerged on 21st and maybe was the culmination of dissent for a long time, culminated in the resolution of 21st of June 2022. It is in this background, my lords, that on 27th of June 2022, we come to this honorable court to say that A, there has been a serious violation of principles of natural justice, because instead of the scheduled period of 7 days, a 2-day period over the weekend is provided to us, and we need more time to file a reply. We also argue Nabam, and I've repeatedly said so. I'm not for a minute ever suggested that we did not argue Nabam. We also argue Nabam to say that quite unlike the cases of Quixote, and this was heard at length, where it says that you will not interfere at an interim stage, Nabam, which is much later in time, takes note of it and says, but where there is a petition pending for the very removal of the speaker, it would be constitutionally and ethically not proper for him to continue. He can always, in the meantime, prove his majority on the floor of the House and then continue with the disqualification petitions, because as Justice Mishra in detail said, that no harm is caused. At the earliest prove your majority, you can lay down the timeline, show that you have the confidence and proceed with the disqualification, but the reversal would be disastrous, because you would then set the pool and composition of the House to suit yourself so that no one can remove you in the meantime. And those entire arguments that your lordship had heard on 14 days, 7 days, etc., would be utilized. And that has to be seen, the then members have to be seen in the context of the notice on the date which was given to you. Your conflict of interest starts on that date when the notice is given to you. And you would utilize that time. And this is what Justice Mishra dealt with in that judgment in Nabam, to say that look at the reverse. Nothing happens in the meantime. If you are, tomorrow you win the confidence, you come back and you win the confidence. But as far as the other party is concerned, it's lost an opportunity to vote against you. Now, my lords, after this, it was keeping this in mind, after hearing arguments of this, the court consciously still only extended, did not injunct the speaker, gave time till the 12th. And of course, my lords, we had also in this raised as a justification for coming in an Article 32 to the Supreme Court was that there was a threat to our lives, homes are being burned, and we read out the press statements of Mr. Raut and others and saying that you'll see a series of dead bodies coming, etc. And we said it's not safe for us to go. And that is why we are out of the state. So these are the principal 3 grounds that we came on. The court consciously on that day said only time is extended, because the period provided as per us was 7 days, which was not complied with. On 27th of June 2022, the second disqualification petition is moved, this time against 22 or 22. Against 22 MLAs is filed by Mr. Prabhu.
It's also 27, is it?
27th, 6, 2022.
Yes, how many MLAs?
22.
From the speaker.
Yes, sir, from the record.
Till date, my lord, subject to correction, I'm instructed to say that no notice has been received or was received, unlike in the case of the first 16, by any of the people against whom disqualification was alleged.
Out of these 22.
Against these 22. On 28th of June 2022, leader of the opposition, Mr. Fadnavis, went to meet the governor and requested him to hold a floor test, as the coalition ministry had lost the confidence of the House.
Sure. Well, may I just say one thing on this second, it's very important, as for reasons I'll point out later, that as far as the second disqualification is concerned, allegedly on 27, first, as my learned friend pointed out, there was no notice. But for the first time, the disqualification petition of the remaining 22 MLAs is concerned is only on the 8th of July petition. Up to 8th of July, it is never alleged that there was any disqualification petition pending. In fact, in all the governments, as I'll point out when I come to it, in all the governments, in every pleading, it has always been said that there are only 16 MLAs disqualified. On the 8th of July, when they filed a petition in this court, for the first time they alleged that there was a 27th July notice or petition for disqualification of 22 MLAs. Actually, the factual matter is there has never been any disqualification petition, to my knowledge, filed till 8th July.
Now, on
Yes.
28th of June 2022,
That's when the leader of the opposition meets the governor and seeks a
the
floor
leader
test.
of the opposition, yes, meets the governor. My Lord, the Chief Justice is absolutely right. And the governor then issues a communication on 28th June 2022 to Mr. Thackeray, directing him to face a floor test on the 30th of June 2022.
So both events of the same day.
Yes, yes. And as I had read out the letter to your lordships yesterday, it specifically refers in detail to three things. One is 7 MLAs who are part of the government, including 2 ministers, withdrawing their support. The letter of the leader of the opposition saying that it has lost its majority, and the resolution of 21/6/2022 passed by 34 of the 55 MLAs saying that there is a huge discontent within the party. And he calls upon Mr. Thackeray to face the floor test on 30th. Now, immediately after that, on 29th of June 2022, Mr. Prabhu files a writ petition before the Supreme Court seeking a stay on the direction calling for the floor test. On the ground that disqualification petitions of 42 MLAs was pending consideration.
That stay is refused by our court on the same.
And my lords, arguments were heard till late evening, and our contention right through was that how can any chief minister ever say that I will not face a floor test, because your lordships have time and again said a floor test should brook no delay. It's the litmus test of democracy. A floor test should be held the moment, and the words used in Bomai by your lordships are, the governor as the constitutional authority is entitled by any means or process to, the words used are by any means or process in para 121 to say, to come to a conclusion that this necessitates a floor test. So when your lordships put that question to me yesterday, my respectful submission was that what else is a governor expected to do? He's not concerned with the 10th schedule, legislative party versus political party. His only concern is, does the government enjoy the majority on the floor of the House or not? Now,
Have you completed the dates? These are the.
sorry, I digress. Let me complete the dates.
Just complete the dates so that.
Yes, my lord. So the court then says the floor test of 30th, and categorically only says the floor test of 30th is subject to the outcome of the proceedings. But that floor test on 30th never happens, because on 29th, Mr. Thackeray, within 10 minutes of this stay being refused, resigns as the chief minister. On 30th June 2022, my lords, Mr. Shinde and Mr. Fadnavis approached the governor as a coalition staking claim to form the government. And on 30th, the governor swore in Mr. Shinde as chief minister and Mr. Fadnavis as deputy chief minister, and directed the new coalition to prove its majority on 4/7/2022.
They are sworn in on the 30th itself.
Yes, my lords.
To the majority on the 4th.
Please, on the 4th. This is 30th first. Now, on 30th, even the minority faction claims that they sent a letter, which is, as per the Election Commission, received on 1st in their office, again bringing to the notice of the Election Commission, as they did on 25th, a change in organizational setup of the party, including Mr. Shinde's removal as the leader of the legislative party.
Mr. Kaul, will you repeat yourself?
Yes. So, lady, on 30th, even the minority faction claims, which, of course, as per the Election Commission, is a letter received on 1st of July, they write to the Election Commission intimating change in the organizational setup of the party, including Mr. Shinde's removal as a leader of the legislative party. He is not removed as a member of the party, but as the leader of the legislature party, is their letter. The purpose that I am emphasizing is that both on 25th and 30th, they themselves invoke and go to the EC, knowing very well that for any dispute, intra-party is a dispute exclusively within the jurisdiction of the Election Commission. Now, on 2nd of July 2022, Mr. Prabhu, purportedly acting as a Shivsena chief whip, issues a whip to the members of Shivsena Legislative Party regarding the election of the Speaker and the confidence motion. As for us, on 21st, he stood removed. He had no authority to issue any such whip. On 2nd, he issues this whip, and this is the first date when their argument of 2(1)(b) of the 10th schedule emerges. Because till now, it's only 2(1)(a), voluntarily giving up the membership of the party while not attending the meeting. On 3rd of July 2022, at 12:01 p.m., Mr. Rahul Narvekar is elected as the Speaker with a total of 164 votes. The same day, my lords, at 12:02, I'm going to show the chart. And the rival candidate only gets, I'm grateful to my learned friend, gets only 107. At 12:01, Rahul Narvekar is elected as the Speaker with a total of 164 votes. On the same day, on 3rd July 2022, at 12:02 p.m., certain MLAs from the former MVA coalition issues a notice for the removal of Mr. Narvekar as Speaker after him having won his election. And after this, on the 3rd itself, they file a fresh disqualification proceeding against all the 39 MLAs, purportedly for voting against the party whip regarding the election of the Speaker. And this they now allege 2(1)(b). On 3rd itself, my lords, Mr. Narvekar recognizes Mr. Gogavle as the chief whip and Mr. Shinde as the leader of the Shivsena party. Which in any case, as per us, on 21st, Mr. Gogavle was appointed and Mr. Shinde, who had been the leader since 2019, we had reiterated our faith in his country.
Yes.
Now, they thereafter also challenge Mr. Narvekar's recognition of Mr. Gogavle and Mr. Shinde before the Supreme Court, which is one of the petitions pending before your lordships. And this time on the ground on Navam Rebria, saying that he cannot proceed with the disqualification as there is a petition against him for removal pending. On 4th of July 2022, the House reaffirms its confidence in the newly elected Speaker, Mr. Narvekar. So, my lords, on 3rd he wins. You again move after his winning. 2 minutes later, he again, the House reposes its confidence on the 4th. And on 4th, then, the confidence motion called for on the floor of the House, wherein Mr. Shinde's government proves its majority in the House. 164 for, 99 against. Now, for a minute, my lords, because there's been so much confusion as I'm reading this timeline, please have this chart as well. It's important. Just hand over. My lords, I've had copies made. Sorry, because this otherwise will be an endless exercise on the numbers. Which, where is the second page?
It's behind zoning page.
आपको देखना नहीं चाहिए था. Lords, I'm so sorry we've printed the. It's typed like this or not?
No.
What is it then?
In election.
On 2nd, when Mr. Prabhu issued the press whip,
Yes. Yes, my
on
lord.
2nd July,
Yes.
he issued the press whip.
Yes.
So according to he could not have because his whip was already removed on
Right.
21st June. That was with respect to the election of the speaker as well as the the trust vote on 4-7.
Yes.
Correct? So can it not
And
be
then-
said? No. Can it not be said that by issuing the fresh whip, correct, they have accepted the calling of the trust vote on 4-7?
Yes.
So you can very well,
I'm-
your submission can.
I'm
be
grateful.
there. They cannot challenge.
I'm grateful. I'm grateful.
Subsequent calling the trust vote on 4-7.
I'm grateful.
Otherwise, they would not issue the whip on 4-7.
I'm grateful, my lords. I'm grateful.
On 2nd
Lordships
July.
are right. Lordships are right. I'm grateful.
But just we wanted to, at least I wanted to know that it was with respect to both speaker election.
Yes,
as well
yes,
as
yes,
no-
yes, my lords. Yes.
Trust vote.
Yes. Now, my lords, kindly have this chart. Now, first, my lords, is the election of the Speaker, Mr. Rahul Narvekar, on 3rd of July, 2022. My lords, has that?
Yes.
Now, please see, this is, I've done the exercise, my lords, both with 42 and without 42. I've done both the exercises on both the Speaker and the confidence. So first it says, my lords, voting in the election of the Speaker, so-and-so, including the 42 members
Against whom disqualified.
against whom disqualification petition was pending. Now, please see, my lords, Shivsena 39, BJP 105, others 20, total votes received by Mr. Rahul Narvekar 164, total votes against Rahul Narvekar 107, absent members 16, total strength of the House 287, strength minus the abstain is 271, majority mark 136, votes secured by Speaker 164. Now please have the one, my lord, where we remove the 42. Shivsena 0, BJP 105, others 17, total votes received by Rahul Narvekar 122, that is 164 minus 42, total votes against Rahul Narvekar 107, absent 16, total strength 245, strength minus abstain 229, majority mark 115, votes obtained 122. Now please have, my lords, on the back of the page, voting in the floor test of the government on 4/7/2022, including 42 members against whom disqualification petitions were pending. Shivsena 39, BJP 105, others 20, votes in favor of Eknath Shinde 164, votes against Mr. Eknath Shinde 99, abstain 24, total strength 287, strength minus abstain votes 263, majority mark 132, majority votes obtained by Eknath Shinde 164, against 107. Now kindly have where 142 are removed. Shiv Sena, so BJP 105, others 20, votes in favor of Eknath Shinde 122, votes against Eknath Shinde 99, abstain 24, total strength 245, strength minus abstain votes 221, majority mark 111, votes secured by Mr. Shinde, discounting 42 MLAs is 122. Now, my lords, I'll come to the issues and I'll proceed issue-wise, my lords, because I have to deal with, as my lords have said, not only each of those issues, but also the issue of legislature party versus political party. But my lords, just before that, there is one submission that I wanted to make, which is we are dealing with three constitutional authorities, my lords. An attempt is to confuse issues as far as the exclusive jurisdiction of each of the three is concerned. The governor, all that he is concerned with is, do you in a democracy have the confidence of the House or not? Now, what better way to test that confidence than a floor test? Having said that, I'm not for a minute suggesting that it's not subject to judicial review, or you can just ask for a floor test for the asking, and there has to be material, there has to be due application of mind. But when an overwhelming number of MLAs write to you for various reasons and say that the concerned government or the ministry does not enjoy confidence, what is wrong with the governor having taken the decision of just given the opportunity to the then chief minister to face a floor test, in fact, rather than dissolving or sending a report to the governor, an act which the Supreme Court repeatedly frowned upon by saying that there used to be a huge misuse of Article 356, where reports to the president were said dissolving the House. They said the first thing is let them face the floor test. What is wrong with it? That is one. Secondly, my lords, comes the issue of the Election Commission. The Election Commission, under the symbols order, decides on what the words used are splinter group stroke rival faction. Those are the words used in para 15 of the symbols order. This whole argument that I have split, I have not merged, is not my argument at all. I have never claimed a split. I am claiming a rival fraction within the party, which according to us represents the Shivsena and has now been recognized as the Shivsena. Because your lordships have held that ultimately when two rival factions emerge within a party, you can't recognize both, is what your lordships' judgments have held, because a symbol can't be split into two. A name can't be split into two. It ultimately has to go to one or the other rival faction. In this case, that's a separate petition, but the competent body has decided to say that I represent the rival faction which should be recognized as the political party. And that's a decision exclusively vested in the Election Commission, Sadiq Ali downwards, including on interim orders, including on deciding whether political majority, legislative majority, two to be taken together, what's the cutoff date, when disputes have arisen, what numbers will be seen. They say they're the only party, only body entitled to and equipped to deal with it. And
Mr. Kaul, for the purposes of the 10th schedule, it makes no difference as to whether the rival faction which has emerged claims to still be within the fold of the erstwhile political party or forms a new political party in the legislature. It makes no difference at all. Once the 10th schedule, the 10th schedule attaches a disqualification the moment you have a rival faction, unless you make out one of the defenses. And it makes absolutely no difference whether you are saying that, well, we are in the same party. We are only saying that we represent the same party. Here, all the dates you have given us make it very clear that there is a rival faction. From the 21st, 34 MLAs represent a rival faction. They say, well, we are the Shivsena. There was a great deal of discontent because you teamed up with the Indian National Congress and the NCP when you were ideologically opposed to them, that we had a pre-poll alliance with the BJP. Fair enough. That's their contention. But does that obviate the fact that this is a rival faction within the meaning of the 10th schedule and a split within the meaning of the 10th schedule?
I was just coming to that. That's why I said three different authorities, three different provisions. I'm not for a minute suggesting that 10th schedule has a bearing there at all as far as the election commission is concerned. The third issue I'll just touch on, my lord.
And you know, a split does not postulate that people who are party to a split leave the party. It may be that the people who split sometimes leave the party. But otherwise, the 10th schedule will also operate where a group of persons, whether minority or majority, say that we belong to the same party.
Yes, my lord.
And though you've constantly said that, you know, the Eknath Shinde faction was the majority and the Uddhav Thackeray faction represented a minority after the 21st, it makes no difference to the application of the 10th schedule as to whether who remains is in the minority.
Yes. Manoj, I'll now answer that. So one, my lords, the governor, as far as the floor test, the election commission, which looks at everything, including the legislature party, the political party, which according to us are integral. You can't segregate them, and comes to a conclusion which rival faction or splinter group should be recognized as the party. Then comes the issue of the scope of 10th schedule. Now, my lords, as far as the 10th schedule is concerned, an attempt is being made to place before your lordships to say that this was only the legislature party, this was not the political party. And in 2(1)(b), what is mentioned is the political party and not the legislature party. And in Mayawati, your lordship said that it is not the legislature party, it's the political party, which is mentioned in 2(1)(b), and it can only be read as the political party. This is what your lordships are told. Now, my lords, I have never ever said that the two are different. Our argument right through has been that this decision of the legislature party has the authority of the political party, and the only interaction that a speaker has while deciding on whether 2(1)(b) has been violated or not is his interaction with the leader of the legislature party and the whip appointed. Because conventions have also shown, and I'll come to those specific Maharashtra Assembly rules have not been shown to your lordships. The members of the legislature party appoint the leader of the legislature party. The leader in turn informs the speaker about all posts, all designations, which necessarily implies also about the whip who's appointed and any change in that. Even when the defense of para 3 existed, there were only two defenses, para 3 and merger in 4. Even when the defense of para 3 and split existed, the Supreme Court in Rana said that the speaker cannot embark on any independent inquiry as to what has happened within the political party in a split within. He will only, for purposes of disqualification, take a prima facie view. In any case, that is today academic because para 3 is gone. Now, what will the speaker today look at? The speaker under 2(1)(b) will look at who has issued the whip. What is the direction? Now, as for us, the whip as on 21st is not Mr. Prabhu. And we are not obliged to follow any direction of his. We are not for a minute suggesting, in fact, our contention has been that the speaker cannot determine. Your lordships are absolutely right. The speaker under 10th schedule is not required to go and determine whether a political party is split or not. That is the EC's jurisdiction. All that they look at is which are the set modes. The set mode is a speaker doesn't embark on finding out in the lakhs of membership who is the political party, who was expelled, who was not expelled. His interaction is with essentially the legislature party. Now, the problem which comes in the argument of the other side is to say, no, the word mentioned is political party, and since the two are separate, you are only relying on the legislature party. That's not our argument. The symbols order, para 6 and 6A, categorically provides that even for the continued recognition of a political party, its vote percentage, its elected representatives, its elected members of parliament are all important to determine the existence and continuance of a political party. So when you say this is legislature, this is political, that's an artificial distinction you are drawing. According to us, that legislature party has the political authority of the political party. And that has been the convention right through. And I'll show two letters. One is on record, one is not. Every time that a whip is communicated to the speaker, it's the legislature party which communicates the whip to the speaker. So this argument which is sought to be made is, and Mayawati said it's only the political party, you are the legislature party, thus you've incurred the wrath of 2-1B.
This is the rules of the Maharashtra legislature.
Yes, my lord. I'm very grateful for that. I'm very grateful.
Those rules are very, very important.
Yes, yes. Show me. Statute compilation, my lords, on
PDF page 4,
PDF page 4,
starting at 6.
starting at 6. Rule 2F.
Yes, sir. 2.
Right. And then I'll go to 15 and 6A and 6B later.
Page 4, compilation 1, page 6. First compilation?
Statute
First
compilation.
compilation.
First.
Yes. Statutes.
Page?
PDF page 6.
What page?
PDF page 6, my lord.
6.
This contains the entire rules or only part of them?
The entire rules.
Because these are the entire rules, I'm told.
Yes, entire disqualification.
You find the entire rules?
Yes, entire disqualification rules.
Yes, the disqualification rules, my lords.
Are these rules?
Because they were framed under para 8 of the 10th schedule.
Yes,
PDF page. Starts there. Statute.
First, my lords, 2 subclause G,
page 7.
page 7, my lords. Then I'll go to the earlier section, but first have 2 subclause G,
Member.
page 7. Member means, my lords, has that? Member means a member of the Maharashtra Legislative Assembly. It says nothing else. Now please have 2 subclause F. Leader in relation to a legislature party means a member of the party chosen by it as its leader and includes any other member of the party authorized by the party to act in the absence of the leader as or discharge the functions of the leader of the party for purposes of these rules. And now kindly have Rule 3, subclause 1. My lords, have Rule 3, subclause 1. May I, my lords?
Yes.
Lord the Chief Justice, may I? Rule 3, information to be furnished by leader of a legislature party. The leader of each legislature party, other than the legislature party consisting of only one member, shall within 30 days after the first sitting of the House, or where such legislature party is formed after the first sitting, within 30 days after its formation, or in either case within such further period as the Speaker may for sufficient cause allow, furnish the following to the Speaker, namely, a statement in writing containing the names of the members of such legislature party, together with other particulars regarding such members as in Form 1, and names of designations of the members of such party who have been authorized by it for communicating with Speaker for purposes of the rules. And now kindly have Rule 3, Subclause 4. Page 8. Whenever any change takes place in the information furnished by the leader of the legislature party under sub-rule 1 or by a member under sub-rule 2, he shall, as soon as may thereafter, and in any case within 30 days from the date on which such change takes place, or within such further period as the Speaker may, for sufficient cause allow, furnish in writing information to the Speaker with respect to such change. So it's the leader of the legislature party who communicates, points out the designations, the posts, and the people who are appointed. And today, clearly within, two rival factions are claiming that their leader is the leader of the legislature party and the whip. Now, the Speaker at this stage, my lords, only goes by what the leader communicates. The Speaker, as your lordships have held, has no independent tools at his disposal to go and find out within a political party where lakhs of taluka, district level, party organizations, members, constitutions are involved. That is how he interacts. Now they attempt to get out of it by saying that you only had a meeting of 34 legislatures, so thus you're only the legislature party. So our contention is, says who? You decide on your own that I have disqualified under 2.1a, you decide I am disqualified under 2.1b, and without a speaker deciding on either of the two. And you tell the court that this is ex facie evident that you have lost your membership, you're hit by the 10th schedule, and so you should be declared disqualified.
So this Form 1 should include whip also?
Manoj,
according to you?
I'm not too sure whether it does.
All posts. All posts.
It does. It does. It does.
It normally does by
Yeah, it does.
practice.
It does. It does. Such members as in Form 1 and names and designations of members who have been authorized.
Who have been authorized by it for communication.
Communicating with the Speaker. So which includes, my lords, communicating in any form, including the views. Now please see.
Yes, the communication,
The two communications.
it talks about the speaker for the purpose of these rules. These rules also relate to the
3.5.
so disqualification.
My lords, now I have 3 subclause 5. Where a member belonging to any political party votes or abstains from voting in the assembly contrary to any direction issued by such political party or by any person or authority authorized by it in this behalf without obtaining in either case the prior permission of such political party, a person or authority, the leader of the legislature party concerned, or where such member is the leader or as the case may be the sole member of such legislature party, such member shall as soon as may be thereafter, and in any case within 30 days from the date of such voting or abstention, inform the Speaker as in Form 2, whether such voting or abstention has or has not been condoned by such political party, person or authority. But today the limited issue before your lordship as far as the 10th schedule is, how does the speaker determine it? They want today the speaker to embark upon and decide what the EC is meant to decide. The legislature party, the political party, according to us, are not distinct. They are co-joint, integral, and organically connected with each other. That is,
The bar who's not gone paperless. So
may I with respect say, from the day this hearing has started, I've been praying that your lordship doesn't ask me this question. But finally it was inevitable and it has fallen on me today. But your lordship can be reassured, I'm trying very hard. And I have this with me and I'm taking some classes and lessons in it, my lords. Give me some time, hopefully I'll be there.
before the next CB.
For sure, my lords. For sure.
Fortunately, the Bar Council group don't contemplate disqualification.
Your other two colleagues have coped up.
Yes, my lords. They are far
Mr. Sibbal.
far more able, my lords.
You have.
We've acted as
Hours. I put in some extra hours to learn. And what is now
My lords, but in all fairness, I've read out a few judgments from this to your lordships. In fairness, and in my defense, my lords, I've read out at least a few judgments from
All the navigation
in other
is being
matters,
done
he has
by-
no defense.
The navigation is the navigation is being done by your junior. You have to also do the navigation yourself. That's also the essence of being paperless. You see,
My lords, your time is precious. If I start doing the navigation at the moment.
all right.
So if that is the layout, please see how have parties understood these rules in terms of communicating to the speaker. Now,
You also can, if you can show us some kind of a practice which has been followed.
yes, that's what I'm coming to. Yes, my lord, that's exactly what I'm coming to. So please immediately now have
So, Mr. Kaul, this only answers half of the contentions raised by the other side, only to show that these names will be forwarded by the leader of the house to the speaker.
yes. No, my lords, absolutely. When I deal with the issue, my lords, I'll deal with it squarely. Since the question fell from my lords, I just attempted to. Just give. Have you got the letters?
Yes, sir.
Have you got the letters? Given it? My lords, one letter is on record. This other letter I don't think is on record, my lords. We've just got copies made. And give one to the to Mr. To the other side as well. Will you give him to the other side?
No, just give.
Yes.
Just.
Mr. Courtmaster says there's an extra copy. Could you return it? I need to give it to the other side.
Thank you.
Very grateful. Now, my lords, as late or recent as 6 July 2022, Mr. Sanjay Rao, as leader of the Shivsena parliamentary party, writes to the speaker to say, this is to inform you that Shivsena parliamentary party has nominated so-and-so as the chief whip in Lok Sabha in place of Srimati Bhavna Gavli MP with immediate effect. And also, my lords, the earlier letter, which is
Convenience compilation.
Convenience Compilation Volume 2,
Yes, 728.
PDF 728,
Convenience.
PDF 728,
This comparison.
Volume 2.
volume 2. Page?
7 to 8.
PDF page 728.
That letter of 25th of November 19 is the one,
Yes.
Yes, yes, my lady.
which is already highlighted.
Yes, it was read out, but I now want to read it in the context of the rules. May I, with your Lordship's permission?
Yes.
To the Honorable Speaker, Shivsena's newly elected MLAs meeting was convened at Shivsena Bhavan, Dadar, Mumbai on Wednesday, 31st 10/2019. The meeting was chaired by Shri Uddhav Thackeray, Shivsena Paksh Pramukh. All the newly elected MLAs of the Shivsena party unanimously resolved that all the decisions of today's meeting be decided by Shri Uddhav Thackeray and authorize Uddhav Thackeray to take all the decisions in the meeting. Thus, Shri Eknath Shinde and Shri Sunil Prabhu were appointed as group leader and chief whip of the Shivsena legislature party in the Maharashtra Legislature Assembly. The resolution passed in this regard are as follows. Resolution 1. It is resolved in the newly elected MLAs meeting of Shivsena party that Shri Eknath Shinde is appointed as the group leader of the Shivsena legislature party in the legislature. It is resolved in the newly elected MLAs meeting of the Shivsena party that Shri Sunil Prabhu is appointed as the chief whip of the Shivsena legislature party, and then all the MLAs.
Who writes this?
This doesn't have a,
This is signed by all the MLAs.
but it has the signature of all the MLAs.
So it's collectively written.
Collectively written. I'm grateful by all the MLAs. And that is why I said, my lords, to that question, that when we come under the 10th schedule, what you're seeking to do is today create a distinction which does not exist. We have never argued the legislature party is separate or the party under the 10th schedule 2(1) means only the legislature party and doesn't mean the political party. That's not our argument. It's always done through the legislature party, at least in majority of cases, my lords. It's never the party president who writes to the speaker.
The call. Please read para one of that, this communication, para one.
Shivsena's newly elected.
Yes. Shivsena's
Newly elected MLAs meeting was convened at the Shivsena Bhavan,
Correct.
Mumbai. The meeting was chaired by so-and-so Shivsena Praksh Pramukh.
Correct.
Right.
Please, now these 4 lines are very important.
Paksh Pramukh.
Because what was the resolution passed? It is only a communication, correct, of the resolution passed, correct? It was a communication.
Yes.
Correct? It is not that the leader is decided by the legislative party. Please read the next resolution.
All the newly
The
elected.
meeting was chaired by so-and-so, so-and-so. All the newly elected members of so-and-so unanimously resolved that all the decisions of today's meeting be decided by so-and-so, so-and-so.
But they authorize it.
My lords, I have right through said the legislature party has the authority of the political party to do so. I'm not for a minute suggesting that that is not so. They have the authority to do so. The communication is through the legislature party and the speaker's interaction is through them. Doesn't mean the political party is not involved.
Naturally, the decision is always communicated, whatever is only by the legislative
Yes.
party and or the leader of the
Yes,
legislative party.
yes,
Ah.
yes, that's all that I'm saying. Now, my lords, let me straight away now.
Exactly. Somebody has
Otherwise, who will communicate?
Yes, yes.
For the speaker is concerned, it is only the leader of the legislative party will communicate.
Absolutely. Now, my lords, when I come to the case law and distinguishing case laws, once I'm through with the rules, I'll distinguish Mayawati. Mayawati is in a completely different context, and I'll deal with that. Rana, Mayawati, all those line of judgment cited, I'll distinguish each one of them. But let me now, my lords, at least start with the issues at hand, which have been referred to your lordships. Let's kindly come first to the second issue because Nabam, your lordships have heard arguments at length. On Nabam, your lordships have heard arguments at length, and I needn't trouble your lordships again until unless called upon. Please have issue B, and I'll go issue wise and deal with your lordship's permission. Power of the commission in relation to splinter groups or rival sections of a recognized political party. When the commission is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the commission may, after taking into account all the available facts and circumstances of the case, and hearing such representatives of the sections or groups and other persons as desired to be heard, decide that one of the such rival section or group or none of such rival section group is that recognized political party, and the decision of the commission shall be binding on all such rival sections or groups. Now kindly compare this, my lords, with para 3 of the 10th schedule as it existed. PDF page 50 of the same compilation.
What page is it?
PDF page 50.
PDF page 50, my lords.
50.
This is something else.
Yes.
Yes.
This is the semi, is that? Yes, that's. Disqualification on ground of defection not to apply in case of split, where a member of a house makes claim that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in his original political party, and such group consists of not less than 1/3 of the members of such legislature party. And now please have B. From the time of such split, such faction shall be deemed to be the political party to which he belongs for purposes of subparagraph 1 of paragraph 2, and to be his original political party for the purposes of this paragraph. So when you split and form a group, that becomes your original political party within 2(1)(b) and saves you from disqualification under 2(1)(b). Whereas under para 15 of the symbols order, within the party itself, a rival faction emerges, goes to the election commission and says, I am the recognized political party. And as your lordships have held, there can't be two recognized political parties within the setup. The symbol can't be split, the name can't be split. So either none of them get it or one of them emerges as the recognized political party within para 15 of the symbols order. Whereas here, after a 1/3 split, it calls itself. It's like saying if Eknath Shinde or Uddhav Thackeray, one of them had split and called themselves the Shivsena Thackeray, the other would have called themselves the Shivsena Shinde. The 1/3 split would have become the new original party. That's not our case. We've never claimed that we have a new original political party. Our political party remains the same.
This, as the first part of the section, a member of the House makes a claim that he or any other member of his legislative party constitute the group representing a faction which has arisen as a result of a split
In his,
which is prior in point of
right, right.
So what is the as a result of the split in his original party?
Right.
Therefore, that must occur prior in point of time.
Right.
In the political party, there must be a split, the consequence of which will be recognized in the legislature.
Right, right. And you will call yourself the new original political party for purposes of 2(1)(b). Now, my lords, in terms of the question that I was addressing your lordships on, which was F, what is the impact of the removal of paragraph 3 of the 10th schedule? My respectful submission, my lords, is that A, a defense which was available is gone, is no longer available to disqualification under the 10th schedule. Only merger as a defense now remains. B, it doesn't concern me at all, because my case has never been, or never have I sought the, nor can I seek the protection, but it's not in the constitution as a protective clause, nor has this been ever been my case. My case is that I, as the faction within the party, represent the recognized political party. And my lords, when I come to the judgments, I'll show to your lordships that this issue, when it arose, and this in itself can never be a 2-1A case either. Merely because a faction says that I'm the recognized political party and goes to the EC for a relief under para 15 of the symbols order doesn't mean he incurs disqualification under 2-1A by saying that I've lost the majority. Because in Yadurappa, this was the exact case which arose. MLAs there went and said, we do not have faith in Mr. Yadurappa. And ultimately, the speaker disqualified them. The Supreme Court said that they have only said we do not have faith in Mr. Yadurappa. They have not said that they don't have faith in the political party or they formed another political party. And such the drastic step taken by the speaker to disqualify them under 2-1A was far beyond what the facts necessitated in the facts of that case. So to say that merely because I go to the governor and I say that here today, given the ideology of the party, the overwhelming cadres don't want to go along with the MVA. Our entire contention has not been that the Shivsena should not form the government. At that stage, our contention wasn't even that the chief minister could not have formed the government with any other political party. Our lack of faith in the ministry was because you were carrying on with a party whose ideology did not match our ideology. We had been in loggerheads for very long. And going along with them was creating a huge discord and discontent amongst the cadres and party workers. Now, can this be treated? By this logic, my lords, any form of internal dissent, anyone raises any voice of dissent, which is the essence of democracy within a political party, would be said that he's incurred the wrath under 2-1A. And I'll show cases of 2-1A, what overt acts have been done in those cases. You go with another rival faction, you go there and say, I'm helping them form the government. I don't have any longer any faith in the political party that I belong to, which is ruling. Those are the kind of overt acts which are 2-1A cases. Here, the only allegation against me at that stage was, you have not attended 2 meetings. In fact, at that stage, the allegation was only that you have not attended the 2 meetings which have been called on 21st and 22nd, and thus you have voluntarily given up the membership of the party, the first disqualification petition and the second disqualification petition, as on 2nd of July 2022. And then came the issue of whip, by when both factions had appointed their whips, leaders, all that dispute arose. That's a separate 2-1B issue. So according to us, my lords, as far as paragraph 3 of the 10th schedule is concerned, A, had it been on the statute book, still, it's not something that I would have relied on. Because according to me, I am the majority. I constitute the recognized political party. And today I have an order also, which is the subject matter of another petition. But my whole case was that under the 15 of the symbols order, I am the faction which represents and ought to be recognized as the original political party. That was my case.
So what does the speaker do in such situations where you raise a claim that you are the political party?
My lords, the speaker is only concerned as far as involuntary membership is concerned. According to me, my lords, this does not constitute an act
Involuntary.
which
We are
on
in this
2-1B,
case
2-1B.
where under 10th schedule violation, they say that there is a violation of the 10th schedule, and you take the plea that it is not a case of a split, but it's a case of reorganization or realignment of the party, and I have the majority of the party. What is the speaker supposed to do there?
Yes.
What is the inference that he is supposed to draw?
So,
will he say that it is not a 10th schedule case?
my lords, what he will say in such a case is, and that has been our case, that his link is with the whip and the leader of the legislature party. That is why I read out those rules of the Maharashtra Legislative Assembly to your lordships, that the members elect a leader. The leader informs the speaker of all the designated posts, the people who will hold various posts. And even when the 10th schedule existed, In Rana's judgment, the Supreme Court said the Speaker cannot embark on an independent inquiry to find out whether there has been a split within the political party at all. Even the prima facie view that he forms, even when 3 was there, was only on the question of prima facie there's been a split. Today, the split is an inconsequential issue because para 3 is not there. Today, the question is of a rival faction and under 2(1)(b, not obeying the orders as communicated through the whip. Now, not communicated by the whip is the issue of which whip do you follow. Now, if the majority of the members of the legislature party, with the political authority of the political party, appoint a leader and appoint a whip, naturally the speaker will be in touch with that whip.
Your answer is that Speaker has no option except to go by the majority of the legislature.
Rule of majority as far as the legislature party for
The context of a 10th schedule.
in the context of 10 schedule.
Only majority.
Majority, and but the mistake which is being sought to be made is to segregate a legislature party and a political party. That legislature party necessarily carries with it the political authority of a political party. And that is where, my lords, para 6A and 6B of the symbols order becomes important, because 6A and 6B of the symbols order both say that for the continued recognition of a political party, the vote percentage, the MLAs, the MPs are all essential for even a political party to survive and continue. So this distinction which is being drawn to say that you've only brought about something in the legislature party and you don't have the support in the political party is wrong. And the Speaker's inquiry is limited in such a case. If the Speaker could do the same thing which the Election Commission could do, then all those lines, my lords, where your lordship said even when para 3 existed, will not embark on an independent inquiry, will only take a prima facie view, whether 1/3 is split or not, because the Speaker does not have the wherewithal, my lords, it's the Election Commission.
In other words, to simplify it, sorry for asking you repeatedly the question. Leave aside their argument of drawing a distinction between political party and a legislative party. Leave that aside. As you are arguing, the only method that the Speaker can adopt in a case where somebody sets up a case of he garnering the entirety of the party is to just go by the number of legislators that he has, that group, that's all.
And be in touch with the whip and the leader of the legislature party as to what are the
Again,
instructions.
there is a problem because there are 2 whips.
Sorry, my lord.
There will be 2 whips.
Right.
So in the teeth of 2 whips, the decision that he has to take is a majority decision.
Because, my lords, your lordships are absolutely right, because the rules say the members of the Legislative Assembly will appoint the leader. If the majority of the members of the Legislative Assembly appoint the leader, and that leader in turn is in touch with the Speaker and communicates all the decisions to him, they are presuming that what is done there does not have the support of the political party. But there is no basis to say so, because they make the mistake of saying that the 2 are separate. And because the 2 are separate, you have done all that you had to do within the legislature party, but you did not have the support in the political party. What is actually proved is quite to the contrary, because today it is shown even by the competent constitutional body, which is the Election Commission of India, that I am the political party. The Speaker's interaction, my lords, is with the whip, with the leader. What are the directions given? He will not embark in to find out what has been the political division in the political party. For that, under 15, otherwise, my lords, if that all could be done under 15A, under 15, the power for determining this very question has been given to the Election Commission, and your lordships have said is the exclusive jurisdiction. And the reason is because when that is done, talukas, districts, MLAs, MPs, percentage of votes, constitution, on the date when disputes arose between parties, what was the stated position of various factions, everything is taken into account. Then, my lords,
does para 15 of the symbols order also necessarily implicate a split within the meaning of para 3 of the erstwhile provision of the 10th schedule, or no?
No, my lords, no.
What does a split the group mean in the symbols order? vis-a-vis the split in three, which is now being
Because
committed.
there are two rival factions
Within a
the
political
party,
party.
Yes.
who emerge. And both claim that we are we are entitled to be the recognized political party. So one of the two, who it is accepted, carries on with the party and the symbol. Then,
So, Mr. Kaul, since that order, just to understand, 15, once it applies and you say the EC's decided it, that's also perspective, right? It obviously can't, the clock can't be put back to what the situation was on 21st.
the EC says that the split, as I said, that order is not, it says that the split occurred on 21st, the rival faction emerged on 21st.
So it relates back to.
Right.
very
And my lady, that's why I pointed out, even on the 25th and 30th, their side, for whatever reasons, on issues which were emerging or simmering within the political party, were already writing to the Election Commission, recognizing the authority of the Election Commission on 25th and 30th. I'll revisit some of
What
those.
you are saying is the pot was boiling, it's just that it was
In fact,
ratified by the
as
Election Commission.
yes, that's another issue I'll touch when I come to that particular issue. According to us, it was simmering for a while. It culminated in the rival factions ultimately by way of a resolution expressing themselves on the 21st of June, led to the events which happened, and ultimately a petition was filed before the Election Commission around the 18th of July. And even that order recognizes all this had started earlier. I don't have to.
Call para 15 does not expressly use the expression split at all.
Right, man. Right.
It doesn't-
I'm very grateful.
Just says which of the factions of the original political party represent the political party. That's the function of the Election Commission. Let's go back to para 15, because one needs to look at what is the relationship between para 15 to the erstwhile para 3.
Yes.
Rival sections.
The marginal note refers to splinter groups. The expression splinter groups is not used in the text of the provision at all.
Yes. Yes.
It says that the text says the rival sections or groups of a recognized political party, each of whom claim to be that party. Para 15 applies in a situation where you have different groups within a party. Each says, I represent the party. I am the Congress. I am the Shivsena. I am the BJP, so on and so forth. None of them have professed to leave the fold of the party.
Right.
So the Election Commission then has the power to determine which of those rival factions represents that party.
Right.
Now, para 3 operated in a very different realm. Para 3 applied in a situation where there is a split within a political party, in which case, provided you had not less than 1/3 of the total membership of the party, that would be deemed to be the original political party for the purpose of the House.
Manoj, may I just
Now-
add to what your lordships are saying?
Right.
They 1/3 leaves. 1/3 leaves under the 10th schedule and says, now treat us as the original political party for purposes of 2-1.
Right. Right.
That other political party continues.
And
The other political party continues from which they split.
so therefore, they're deeming fiction that therefore the 1/3 then is deemed to be the original political